You said that if a secondary search came into play, that you would start looking at things that piqued their interest and that the officer has discretion at the scene. How do you reconcile that with the New York case, which you said you try to follow, which says that the search can be solely for the purpose of explosives?
Well, if the X-ray raised the question, or it made, let's say you had a device inside your briefcase that had wires sticking off of it, or a blow dryer, something that was out of the ordinary that your average customer wouldn't be carrying, and the X-ray revealed that, then a secondary search would have to take place for that individual's safety and the safety of others.
But again, the court ruling speaks to searching for explosives, not for air dryers and stuff like that. It sounds like this is can turn into a real fishing expedition.
Now, you got to remember, the only reason a secondary search would take place is if it came back as a positive from the scanning machine. We're not X-raying every bag that comes through the station or every customer that we stop.
I understand that.
It's a case-by-case basis based off that ionization technology that detected an explosive, traced explosive.
I understand that, but the secondary search can't be for a different purpose than the primary search.
Okay, I'll defer to Bruce Hepburn from our legal counsel.
I'm the Deputy General Counsel for Civil Law. The only issue that's in the McQuaid case is the question of constitutionality of the program. Under Fourth Amendment law, the issue of what you have, what quantum you need, or what the circumstances are for an initial search is very different from what happens if there's something detected. The McCain case is not addressing that issue at all. It's addressing the so-called administrative search and what the criteria are for balancing privacy interests against the reasonableness of the state interest in preventing terrorism or whatever is the articulated state interest. The court really isn't addressing, the McCain case is not addressing that issue of what happens if something is found. If something is found, that in itself can provide probable cause for a more intrusive search. But that's not what we're talking about here, because we're only talking about the initial search, which is, unlike the McCain case, does not involve anybody looking into the contents of anybody's bag. The initial search is simply a swab. The McCain case, which upheld the constitutionality, involved opening a bag and some peering into the bag to see what was there. So if anything, the program that's being used here is less intrusive and it's more respectful of individual rights.
Doesn't have the characteristics of terror.
So how many bags were X-rayed in the actual case?